be sure. But it was my understanding that Mr. Hobbs is not representing him.
Okay. Well, and I assume you're going to stay in. You need to, assuming the paperwork is accurate and you were appointed, you're in the case until someone else files an entry. So we'll see you.
Yes, Your Honor, definitely.
Great. All right. We will see who comes next. Are you Mr. Is it pronounced Gao?
Gotham.
Oh, Gotham. That's right. Someone told me that. How are you?
I'm good, Judge. How are you?
Welcome. You ready to be busy? You were in DeKalb?
Well, I was in Fulton for 5 years, and then I left January of last year. But yeah, that January.
Well, that was a brief absence.
That was, and most of it was during COVID.
When you left Fulton, what was your role?
I was in case.
So you're coming home. And Mr. Dutcher was there before, and he's here now. All right.
Mr. Rao, I sent you a text message earlier today as well. If you could, when you get a chance, let me know if you could help me out with that.
Gotcha. Okay.
Can you turn your microphone on, please? I think that'll help. Great. I mean, I could hear you just fine, but the rest of the world. I assume you're here for the Remy matter.
Yes, sir.
Okay. So for those of you who are new to using these jail booths, I'm just waiting for someone else to show up, and then we'll jump to that. What you heard, here comes someone, 5 South. Let me unmute that. That's pretty annoying. It keeps expiring.
What's your the Zoom is?
No, when I try to get into the controllers, there's this link that I click and it keeps expiring.
Revocation.
Hello. Who do we have in 5 South?
I got position number 3, Mr. Gregory Watson, Your Honor.
Thank you. Hey, Mr. Watson, how you doing?
How you doing, Your Honor?
I'm doing all right. Mr. Watson, you are here today in the booth number 1 on 5 South to talk about a probation revocation. You pled guilty a while ago to an aggravated assault case, and the allegation in the petition is that in February of this year, you picked up a new charge of robbery and maybe a drug charge as well. So we need to talk about that a little bit. Mr. Franklin, are you handling Mr. Watson's case?
Yes and no. It's more so like we're going to be handling the announcement of kind of where the direction we'll be going from here.
Okay.
Myself and Ms. Hall had a conversation yesterday, and Mr. Watson, as the court has kind of become familiar with, is being held not only in the probation warrant, but also on a CP case related to the substantive charge that is the basis of the probation revocation.
Mhm.
So we, in our discussions, we thought it best that, again, we wait for the potential indictment for the state to make a decision on that portion of things, because otherwise we'd be duplicating work.
Okay, so let me see if I can distill that. So the CP case that ends in 521 for Mr. Watson is a robbery by force and then a couple drug charges. And in February, Mr. Watson was denied bond. So what you're suggesting is that rather than have a full-blown evidentiary hearing in the context of a revocation, let's see if it can get indicted and then maybe resolve the indictment in connection with the revocation.
Yes, sir.
Okay. Ms. Hall, and when you say yes or no, I guess your point is he'll get indicted in theory someday and then randomly assigned. So it could go to Judge Dunaway, in which case your colleague in Judge Dunaway's courtroom would be helping Mr. Watson figure out the best way to move forward.
Correct. In the event that, they figure out that the case is not worth anything, then I would expect that the substantive case would be dismissed, and certainly the revocation based on that would be dismissed.
Sure.
Or if it were to work out in a resolution by plea, then similarly, because it's the same activity, that it would likely be run concurrent to one another.
Okay. So my thought would be to go along with that. I'll hear from Ms. Hall in a minute. The only other tripwire out there would be if for some reason you learn, Mr. Franklin, that Mr. Watson is able to get a bond and make the bond in the CP case, then we ought to revisit this probation piece, because that's what would be holding him in custody. Right now, he's got two things holding him, and neither one is budging. We're not going to deal with the probation until there's an indictment, but he's got no bond on the robbery. Does that make sense?
Yes, sir.
Okay. Ms. Hall, do you agree with all that?
Sure.
Okay. So, Mr. Watson, we were just checking in to make sure nothing had changed. You've got these new charges. They may not feel so new to you now. They're from February. But we've got the new charges. You do not have a bond on those. So you're in jail right now for those new charges. Then you've got this probation piece that's all about the new charges. So they're sort of one and the same. And Mr. Franklin is wisely saying, let's figure out what's happening with the new charges before we worry about the probation piece. Does that make sense to you?
Me?
You.
No, because why? It ain't no case, because where I'm from, Your Honor, everything go by facts and logic. So when a person say that I robbed somebody, and when the APD pulled up on me, I didn't possess nothing of that man's property. I had everything of my property on me.
So I don't want you to get into a lot of the facts and allegations, but it does sound like you have a defense and that you're going to talk to a lawyer about that. Mr. Franklin wasn't suggesting by anything he said that the state had a good case or a bad case. He was simply saying because you do not have a bond on those new charges, there's not a whole lot that makes sense to do with the probation piece on your old case until the state figures out what it's going to do. It may be that your lawyer helps you get a bond on this robbery charge that you say is a bogus charge. Then we'll be back together. But until something like that happens, I think we're going to sit tight on your old case, okay?
Well, could you at least tell my lawyer to come visit me, because I've been here going on 120 days. I haven't even talked to that man not one time.
So I can ask Mr. Franklin to reach out to him. Mr. Franklin, it indicates that Mr. Cho would be the lawyer who's handling Mr. Watson's case, along with probably 80,000 other cases that he's got. But if you wouldn't mind just letting Mr. Cho know, assuming that's the correct person still handling Mr. Watson's case, that would be great.
Yeah, it may be easy for me to pay Mr. Watson a visit and just relay whatever message to Mr. Cho. Because like
Sure.
I said, the division that Mr. Cho is in, he has hundreds of clients at this point, and he may not get to Mr. Watson until there's another hearing. Yes,
Great. So Mr. Watson, yes, sir.
I was going to ask you, I'd rather have Devin Franklin as my lawyer anyway.
But wouldn't we all? He will come visit you, and I appreciate that offer. That's very gracious of him. It's not like he's got a small caseload as well, but he's going to come talk to you about next steps. And I'll tell you, if you and he come up with a different plan, he knows how to reach out to my litigation manager, and we'll try something different. But what he suggested makes sense to me. He can come talk to you about it. And if you guys change your mind, just let me know. Okay?
Okay.
All right. Thank you, sir.
I agree.
So, wonder who will be next. In theory, Mr. Hobbs is supposed to be on this call for Mr. Horn.
Yeah, I sent Mr. Hobbs a text message just in case. He and I were pretty close personally. So he may text back or hop on. So
Okay. Thank you. So did you come back, Mr. Rao, to major case just recently, or you've been in other courtrooms?
I was in other courts, Judge. Yes,
So do you now have 3 courtrooms?
I have 4.
4?
Yeah, I came back to 4.
Okay. All right. We've got 4 north. Let me see if I can activate that. 4 north. Ooh, it's looking promising. All right.
Okay.
There we
Y'all
go.
know position number 1 and number 2, Mr. Reed.
Mr. Reed in 4 north. Excellent. Thank you so much. We've got Mr. Bridges and we've got Ms. Hall. All right. I remember Mr. Reed. He is notable in the sheer volume of unindicted cases he has. He has 9 unindicted CP cases. Regrettably, he's been in that position for a while, and we're trying to figure out what is next for Mr. Reed. So I'm going to start with Ms. Hall. Why don't you tell me what you've been able to get from your esteemed charging unit as to what's happening with Mr. Reed?
Your Honor, we have started getting evidence back from APD for the 8 burglary cases. The intake department intends to indict those cases in the next 30 days. But the one case that ends in 184, That is a DV case. That case is going to be presented to the grand jury on the 14th of this month.
Okay, so it's 8 alleged burglaries and then some alleged felony domestic violence situation.
Yes, Your Honor.
Got it. So you would get the 8 burglary. Well, they wouldn't come to us. Someone would get the 8 burglaries, and then, or are these open? We will get them. Are 18 SC and 19 SC open cases? That's all right. I'll look them up.
Yes, Your Honor, they are open cases.
Okay, so then we're going to get the 8 burglaries, and so you would get the 8 burglaries, Ms. Hall, and then someone out there would handle the domestic violence piece.
Yes, Your Honor.
Okay.
It should still be assigned to our courtroom as well. Right now, Ms. Hilton has it.
Okay. So your understanding is next week 1, and then within 30 days, the remaining 8.
Yes, Your Honor.
Okay. Have you and Mr. Bridges had any discussion about what's going to happen? One of the open cases, the 19 SC, is 4 counts of burglary in the 2nd degree. I think we've resolved against at least one of the co-defendants. What have you and Mr. Bridges discussed, if anything?
We haven't talked about any of the cases as of yet, Your Honor. When I last checked with intake, we hadn't had any of the evidence. So I wanted that stuff to start coming in so I could get that to Mr. Bridges so we can have a decent conversation, because there's a lot of burglaries and a lot of victims.
Okay. Do you know, just offhand, if the burglaries, the unindicted, are 1st degree or 2nd degree? Like, are they residential burglaries or are they commercial burglaries?
I understand. I just can't remember which.
Commercial.
Okay.
Okay. Got it. Okay. Mr. Bridges, tell me your thoughts about where we're going with Mr. Reed.
Your Honor, it sounds like Ms. Hall and them are making progress. She sent me an email confirming what she just told you. Mr. Reed also has a bond hearing on the domestic case on Monday.
Oh, okay. Let me look that up. He does indeed. So he had bond denied back in November. Okay. And that'll be revisited on Monday. Okay. And Mr. Bridges, are you juggling all these things? So you'll be the person there on Monday?
Yes, Your Honor.
Okay. And you are also responsible for the 8 unindicted burglaries, as far as you know?
Yes, Your Honor. I have all of Mr. Reed's cases.
Okay, that's actually very helpful. I know that's quite a workload for you, but then you are the one-stop shop in terms of understanding what's going on from a defense perspective for Mr. Reed.
Correct, Your Honor. If me and Ms. Hall can reach a goal of resolution of the case, it'd be best that one person's handling it all.
Okay. All right. Well, this was on for inquiry just to understand where we were. It sounds like the bond hearing on Monday may change what's going on. Is there, Ms. Hall, no, that's not what it would be. Okay. Do you know, Mr. Bridges, does Mr. Reed have bond in the unindicted burglary? So it's just the aggravated assault that's keeping him in custody, or is it a mix?
It's a mix, Your Honor. The only cases he has bonds on are the 2 that have been indicted that are before the court.
Got it. Okay. All right. Well, that's helpful. Mr. Reed, do you have any procedural questions? We should not talk about the facts of your case. That's something for you and Mr. Bridges to discuss. But I just want to make sure you've got a feel for what's happening. You'll be, I don't know if it'll be on Zoom or in person. I suspect it'll be on Zoom. You'll have a bond hearing on Monday for the case where you're charged with having assaulted someone with whom you have a close relationship. You understand that? Okay. You got any procedural questions about anything?
No, I don't. No.
Okay. Well, it's good to see you. We're going to keep tracking this. When the state does indict these cases, if they do, the procedurally good news is that it'll all be with me. So you've got the right defense attorney here, we've got the prosecutor, and we'll be able to start making something happen, whatever that something is, whether it's you wanting a trial or you wanting to work it out. We should be able to start taking care of that now that the grand juries are doing what they need to do. Yes, ma'am.
I just want to I met him every day since October.
Okay.
Can we be able to get the bonding on all the cases Monday so he can get out because he's been here since October the 31st?
So it sounds like Monday is a bond hearing on the one case, not the 9 cases. But it's one that is very, very different from the other cases based on the charges. So we'll see how that goes. That won't be in front of me. That'll be in front of a different judge. But that will be progress in terms of understanding whether Mr. Reed is going to get a bond. I think you can understand why a judge might be reluctant to give a bond, even though he's been in for a while. 9 cases is a real big number. There are not a lot of defendants sitting in the county jail who have 9 unindicted cases. And that may cause a judge to be uncomfortable setting a bond.
But if you go to a bond hearing Monday, even though they might give him a bond on one charge, and even if he can make that bond, he still won't get it.
Correct. But then what needs to happen, and it sounds like Mr. Bridges is working hard on that, is to get bond hearings on those other burglary cases. I don't know why they're moving separately, other than that the charges are very different. And so it may even be a different set of prosecutors handling the different cases. But I appreciate why you're frustrated. I know Mr. Reed is frustrated. He's told me as much. He's in a complicated situation. You know, he's got 2 cases already indicted that I've got, and then these 9 other cases. And I think that makes some people not real interested in setting a bond. But what we need to do is move the cases one way or the other, because your point's the real important one, which is what's been going on since Halloween of last year. That's 7-8 months now, and Mr. Reed's been stuck. A lot of folks have been stuck because of the pandemic, but we are now starting to move cases again. And it sounds like, from what Ms. Hall said, if you were able to hear her, that the district attorney's office plans on indicting the domestic violence case next week. That's big progress. And then the 8 burglaries within the next few weeks. Now, you and I have both heard that before. We'll see what happens.
Yeah, but we was here, I can't remember what date it was. He was trying to get all of them concurrent together so he would not be coming back and forth to court. And I've been coming to court, even when they didn't bring him here last month. I was still here when they didn't bring him to court. And I have not missed the court date since he went.
None that I remember. You haven't missed any of that. Mr. Reed benefits from good family support, and that's something that probably the judge will consider on Monday, and it's something that any judge will consider when it's time for Mr. Reed to resolve all these cases. So we'll hold a thought on Monday that it goes smoothly, but at least that's a chance for Mr. Reed, his lawyer, Mr. Bridges, and if you're there, for you to articulate to the judge, you know, how long is too long? And the judge will hopefully listen closely, and we'll be weighing those competing concerns. We've got someone who's presumed innocent on all these cases, stuck in jail for month after month, but we've got someone who has been charged with so many cases. You wouldn't want to be that judge who says, all right, I'll give you a bond, and then there's another burglary. I mean, how do you explain that to the next victim? Or that person is going to say, why would you have given a bond to someone who had eight unindicted burglaries? Why did you think things were going to go okay this time, Judge? So It's not an easy decision, and I think people should be frustrated on both sides. But I appreciate you being here again. All right. Thank you, Mr. Reed. Thank you, Mr. Bridges.
All right, Your Honor, have a good day and a good weekend.
Okay.
I see.
No?
Yeah.
What is that? 4 North. Got to mute 4 North. Done. All right. 7 South is the one that doesn't show anything.
Select. Just.
So that leaves Mr. Horn and Mr. Remy, who are both supposedly in 2 South. See what happens. That poor deputy's having the.
The other one was in background team entirely different. What we just said.
Well, they move. Mr. Franklin, who do you have with you?
So, Judge, you can see in the background, this is Daniel Cook. He is a rising 2L. He attends New York University Law School. So he is going to be working with myself and Ms. Patel this summer. So you'll see his smiling face.
Fantastic. Welcome, Mr. Cook. You're in good hands. Should be an interesting summer. We're starting to get more and more stuff happening in court, so it may not be entirely virtual like today.
Great. Thank you, Your Honor. It's great to meet you.
Say he has some hopes. We've been doing some trial prep stuff today.
Good.
So he's found that pretty interesting. And actually, Mr. Rao is the district attorney who's handling that case we're working on. Is there actually going to be a list printed, Judge? Do we know kind of where we are on the list for those cases?
I'll get you wherever you need, but I'm not sure what you mean.
I know that we were kind of tentatively on the trial calendar for the 21st and the 28th. If we have any indication if one week is more likely than the other.
So there'll be an actual calendar generated, and then with cases from a bunch of judges, and then we'll work through. And it'll be published in the order in which things are supposed to be tried, because it's generally published with the oldest case ranked by number of days in jail first. So if your client is number 9 on the calendar, that gives you a feel. Probably not week 1, but couple caveats. Lots of cases end up resolving. And so the calendar that's going on right now, we're not having a trial next week because so many things pled. There are only 2 cases left, positions like 18 and 19, and they are cases that can only be tried the week of the 14th. So Ms. Nelson and I can keep you posted so you can plan, but we fall in line behind older cases. And so I don't know which one you're referring to. If it's something that's real old, we'll be at the top of the calendar. And then you'll just want to be tracking if there are cases ahead of yours, whether they've been resolved or not. And they'll likely be cases belonging to your colleagues. And so you can talk with them about the likelihood of resolution. But the calendars get published about 2 or 3 weeks in advance. So you ought to be able to get it that way.
Very well, thank you.
All right, let me turn on to South.
Hey, Your Honor, this is position number 4, Mr. Horn. Position number 4.
Fantastic. Thank you. Hello, Mr. Horn.
How you doing?
I'm okay. Mr. Horn, is your lawyer Mr. Hobbs?
Well, he was originally on this case.
Oh, so it was when Mr. Hobbs was with the public defender's office?
Yes.
That's how old this is. Okay. Sir.
I expect that I'll be handling it today, Judge.
Okay, thank you.
So I'll make the announcement. I know Ms. Hall's voice is not cooperating much today. It was working a little bit yesterday and we were able to have a conversation. If Mr. Horn and I could pop out to a breakout room.
Yep.
We have an offer on the table for a resolution that I think Mr. Horn would be interested in.
Okay, I will put the two of you in a breakout room in just a moment. I want to get up to speed on it. So I'm looking at the petition. So Mr. Horn pled guilty in September of 2015 to a heroin charge and some related offenses. And the allegation that in 2016, this is an old petition. Got it. In 2016, so Judge Downs signed this petition. This is something that caught up with Mr. Horn many years later, effectively. Right. We ought to be able to work this out. Let me get the two of you into a breakout room.
Your Honor. Your Honor.
Yes, ma'am.
I'm sorry to interrupt. I just wanted to put out there, he only has 3 months, 10 days remaining on that case.
Fantastic. Thank you for sharing that.
Mm-hmm.
3 months, 10 days. We may be drawing to a close here. Let me get Mr. Horn and Mr. Franklin into a breakout room. Great. Got the right settings. So this should do it. Mr. Horn, you should be moved automatically into the breakout room. When you see it's just you and Mr. Franklin, you guys are in a private space. Whatever you say and he says, no one else can hear, okay?
Yes, sir.
All right, let's see if we can make it work. All right. So, Mr. Rao, what are your other courtrooms?
I am in Judge Adams, Judge Ellaby, and yes, Judge Newkirk, soon to be Judge Grant.
It's an interesting mix. All right. Yeah, Glanville is done with family division. He milked it as long as he could, but he has to come back. And Newkirk could not get anyone to.
No one wanted to volunteer.
Judge Glanville was, I think, moved independent when I was still in trial.
It's been a minute. What is Judge Newkirk's case count like? Is it pretty manageable or is that a big one?
So I think major cases kept 16 murders, but I think the total count is somewhere close to 30, which obviously doesn't fit fragment to and divided into other units again. SQ.
What is your count here, as best you think?
My understanding, I think it's 12 cases that I've kept, including, I think, not including Mr. Remy, although it's, I think, we're part of prosecuting search phase.
We'll discuss soon.
Judge, are there any homicides? I know Mr. Goolsby's potentially set as a trial for the last 2 weeks in June. Are there any other homicides that you think may be going on that calendar day?
So the way we've worked it, and you were not part of that correspondence, maybe Ms. Ocom could forward you the emails. I periodically had reached out to the defense attorney saying, which ones are you comfortable trying given the format in which we're trying cases these days? They're back. We'll keep talking. All right, Mr. Franklin, give me a minute. The magic is making sure your client comes back too. And I need to make sure that happens. He was in 2 South. So let me do that. He should be with us in 6 seconds. And Mr. Horn, are you back?
Yes, sir.
Fantastic. I am proud of my technological acumen. Mr. Horn, did you get a chance to talk with Mr. Franklin?
Yes, sir, I did.
Do you need any more time to speak with him, or can we move forward?
I would like to move forward.
Okay. Well, Mr. Franklin, it sounds like Ms. Hall is going to let you keep the microphone, if you will. So why don't you tell me what you and Ms. Hall negotiated as a possible resolution of Mr. Horn's probation situation?
Yes, sir. So Mr. Horn has been in Fulton County custody for 20 days. He has an additional 4 days or so that he spent in custody in LaGrange, Georgia, where he was arrested. Was involved in an argument. Police ran his name, saw that he had this warrant, and was eventually brought back here. So in light of the fact that he served 20 days, that the violating offenses are misdemeanors and pretty old misdemeanors, she has agreed to revoke 20 days. And in light of the fact that he hasn't had any trouble in about at least 4 years, thereabout, and that there are only 3 months and 10 days or so remaining, she has agreed to terminate the balance of the probation. So essentially revoking for the time that he served and terminating the probation.
Okay. Is it Miss Colors or Officer Colors?
I'm Miss.
Okay.
Yes,
Hey, Miss Colors.
Okay.
Do you have any indication that Mr. Horn has had a felony arrest or any felony convictions since 2015?
No,
Maybe.
sir. I did look in Odyssey, and I tried to do a rap sheet for him, and I didn't see anything.
Okay. So, Mr. Horn, well, Ms. Hall, you can just raise your hand if that's easier. Is what Mr. Franklin described effectively what you and he negotiated? Okay, thumbs up. Excellent. Okay. So, Mr. Horn, it sounds like the recommendation is that I sentence you effectively to time served, and that the balance of your probation be terminated. It's almost at an end anyway. Are you living in LaGrange normally?
No, sir, we was just there at the water park on vacation.
Where is home?
Sandy Springs.
Say that again?
Sandy Springs.
Sandy Springs, okay. You were down in LaGrange, got arrested, and you've been in jail now for about a month, or less than a month.
Yes, sir.
Okay. Are you employed, or were you employed when you got arrested?
Yes, sir, I have a lawn service.
A lawn service. Who's running it while you've been out? It's a busy time for lawn services.
It's down. I'm losing most of my customers, and one of my employees ran off with some equipment and just.
Okay. Sounds like you need to get back. Yeah, I would not want you as my lawn service guy if you could only come once a month. That would be for a very long lawn. Well, Mr. Horn, I do find that you violated the terms of your probation. Sounds like way back in January of 2016, you were driving in a way you shouldn't have been driving. And at some point you moved and didn't let probation know that you moved. But that again was way back in 2016. Since then, you stayed out of trouble. More importantly, it sounds like you've been doing productive things, running your own business, et cetera. And we ought to try to get you back to that. So based on the joint recommendation, I will revoke 30 days of your probation, but I will reduce that to the time you served. And then, Ms. Cullors, I don't know the magic language. I don't think we need to suspend the balance. I think we can just terminate the probation. There doesn't need to be a quiet clock ticking. We can just say Mr. Horn is done with the many years of probation that he had.
Yes, sir. I can do it that way.
Fantastic. Okay. Mr. Franklin, anything else on behalf of Mr. Horn?
No, sir.
Ms. Hall? No, she shook her head no. Mr. Horn, I'll sign the paperwork that I get today-ish. I don't know that you'll get out today. If you are still in the jail Monday, you need to reach out to Mr. Franklin and say something didn't happen, and we'll figure out what did not happen, okay?
So,
All
Judge McBurney, he and I spoke about that. So he still is substantively held on the state court case. So the DUI, there's an actual actual case, and being that it's state court, I know we couldn't deal with it, but.
So it's an unresolved, it's not just that he got a DUI arrest and dealt with it, but that thing has been lurking out there as a open case, if you will.
Yes, sir.
Okay, well, that doesn't change what I'm going to do, Mr. Horn. I'll still revoke 30 days, but reduce it to the time you served. You're going to need to sort out that DUI, however you sort it out. But that's a helpful piece of information from Mr. Franklin. You may still be in jail on Monday. That's not because I didn't keep up my end of the bargain. It's because you need to take care of your business in state court, okay? Does that make sense?
Yes, sir.
Okay, all right. Good luck with everything.
Thank you.
Take care, Mr. Horn.
Yes, sir.
Your Honor, we got Mr. Remy on your supplemental calendar.
Yes, sir, that should be it.
That's it.
Mr. Raines, I've seen your name on there. You ready to join us?
Sir?
You're Mr. Remy. I'm trying to get the lawyer who represented you before. He's on this call. I'm just trying to get him plugged in here.
Okay.
I'm here, Judge.
There he is. How you doing, Mr. Raines?
I'm doing good, sir. I'm sorry. So I was taking a little self-care break, so I'm not all the way in my attire, but I knew this meeting was set up for today.
That's okay. We won't hold that against you. You look sharp. You just don't look like you're in court. So that's okay. So let me sort of take attendance here. We've got Mr. Remy, who is in custody, and he is in a booth on 2 South. We have the lawyer who represented Mr. Remy for purposes of trial and the post-trial litigation. That's Mr. Raines. We have a major case prosecutor here in court, Mr. Rao, who is newest to the case. I would be second newest. But let me explain what I understand the posture to be. Mr. Remy had a trial, and I believe it was after the trial, another judge, my predecessor in this division, granted an immunity motion. The state appealed that decision, in part arguing you can't do that after the trial, maybe beforehand, but not after. Went all the way up to the Supreme Court, and the net effect of the Supreme Court's rulings are that there is still an active indictment out there. I think a number of the charges for this superseding indictment that Judge Downs sua sponte dismissed, and I think she was told she can't do that. the net effect of the appellate opinion is that most of the charges of the open indictment cannot be proceeded upon in light of the immunity ruling, but there's a firearm possession charge that is still out there and is arguably viable. I'm not asking anyone to agree or disagree at this point. We just need to figure out what's next for Mr. Remy, because he's in jail, and there is a deceased. His family members are watching this proceeding through Zoom. Through YouTube right now. They're anxious to know what's happening next as well. So I think I'm going to start with the prosecutor and find out what Mr. Rao thinks the right next step is for the state. And then Mr. Raines, you can let me know, whether you're even on the case anymore. That may be a discussion you need to have with Mr. Remy and his family. But let's start with the prosecutor. Mr. Rao?
Yes, Judge.
It appears that we would be barred from prosecuting counts 1 through 5 under 18 SC 159105 per the immunity order through the immunity motion, as well as the judgment by the Supreme Court. So that leaves counts 6 and 7. And in my understanding, the theory behind re-indicting it and adding count 7 was to indict a possession of a firearm by convicted felon charge to prove that the defendant had a firearm on his person either prior to the engagement or after, which from my perspective in reading the defendant's testimony at trial, we can certainly prove. So it is our intention to either go forward on count 6 or 7. I believe probably the most appropriate count to go forward on would be count 7 on this indictment. And that's the posture that the state is maintaining. My understanding is that the minimum sentence that the defendant could receive is 1 year to a maximum 5 years. I believe from my count yesterday, the defendant has served a total of 793 days in custody, to include the time that he served under the 16 SC indictment, as well as the time that he has served since he was arrested and transported to the Fulton County Jail after the bench warrant.
Okay.
So that's the state's position, Judge.
Got it. Mr. Raines, were you able to hear all that?
I heard it, Judge. And Judge, my position is, first, I will ask the court to set aside the bench warrant. Mr. Remy, I don't think he ever received adequate notice. The address that he had once he was originally arrested back in 17 or 18, I don't recall the exact date. I don't think it was the address that he was residing at once this remitted came back from the Supreme Court. So, Judge, the first thing I would ask the court to do is set aside this bench warrant and allow him to be released. He's an over-the-road truck driver. He's lost a substantial amount of money since he's been in custody from Illinois and being extradited from Illinois back to Georgia. As far as the posture of the case, Judge, I agree with what the state recited as to the only remaining count in the indictment is the possession of a firearm by a convicted felon. I do think, Judge, we're going to have some venue problems because initially Mr. Remy had traveled to Fulton County from DeKalb County. So I'm not sure if Fulton County would be the proper venue to prosecute the possession of a firearm by a convicted felon count.
Okay, let me take one step back from what you've just described, all of which I think I follow. Mr. Raines, are you remaining counsel of record for Mr. Remy?
I'm not sure, Your Honor. I actually just emailed Ms. Stanley, Janae Stanley over at the Georgia Public Defender Standards Council. This was an appointed case for me. And I just asked her, what am I to do? Because I know he had a different appellate counsel. So I'm not sure the trial counsel posture at this point. So, Your Honor, what I would like to do, sir, is continue this to your next status conference. But I, more than anything, want to get this bench warrant lifted on this gentleman because I don't think he ever received proper notice. And to his knowledge, he was exonerated from this. So I don't think it's fair to him to hold him in contempt of court when he never received notice about the court date back on March 25th. So I don't know, Judge. To answer your question is, am I still on the case or not? I emailed Ms. Stanley a couple hours ago about it, like what should I do? But I'm certain she hadn't responded back yet. As of the time this hearing started, I haven't received a response back from her.
Okay. Well, it sounds like you are willing to serve as counsel for purposes of today's discussion. Whether you remain on after that is to be determined.
Yes, sir.
Okay. Mr. Remy, what is your city of residence these days? If you were released, where would you go home to?
I mean, I actually been, like Mr. Rain said, I've been truck driving, so I technically been living in my truck, but I am stationed in Snellville, Georgia, at my parents' residence at 3495 Revere Circle. That's in Snellville, Georgia.
Okay.
Sorry, I didn't hear that answer, Judge.
Yeah, I'm sorry. It sounds like there's some kind of alarm or something going off on Mr. Remy's floor. What Mr. Remy said is that he's an over-the-road trucker, and so he is often living in his truck, as truck drivers are wont to do. But there is a stable address, his parents' address, which, interestingly enough, is where we send correspondence in this case. And that is, because it's in the system right here, it's 3495 Revere Circle in Snellville. So I'm not sure why Mr. Remy wasn't getting word of what was going on. Everything that gets sent to Mr. Remy goes to that address. Who lives at that Snellville address? Your parents, Mr. Remy?
Yes, and my grandfather.
Your grandfather or your parents?
My parents and my grandfather.
Got it, both. All right. Is there room there for you to stay as well?
Yes, but every time I come off the road for a home time, that's where I go.
Okay. Would you be able to limit your work to within the state of Georgia? Or do you only take loads that require you to go to Wyoming or Tennessee or out of state?
I'm probably gonna have to reapply for a local job because I'm pretty sure this situation caused me to lose my job with the company I was just with. So, I'm pretty sure, hopefully by the grace of God, I'll be able to get accepted by something that's local and I could just be home, until this gets resolved.
Okay. I'm just looking at your old case. Wonder where we got that address. So was it, maybe it was recently updated to have this Revere after he got, maybe after he got arrested?
That's correct, Judge. It was recently updated.
Okay, so the Cherry Glen Road is old for, got it.
That's correct, sir.
Okay. All right, just give me a second while I look at. So do you, Mr. Remy, did you ever get a bond in your old case, or were you in custody from the time you were arrested until when did you get out?
Judge, I can explain it, sir.
Sure.
What happened is when Judge Downs granted the immunity motion, she also granted
I see it.
him, she granted an OR bond, or I think a dismissal was sent to the jail and he was just released on his own recognizance. So he never had to post a cash or a property or commercial bond. So
yeah, I just found it. It was from April of 2018. It was a $20,000 bond through the pretrial 10% program, and Judge Downs had a handwritten note on it as to why he should have a bond. So that is the bond that in theory could be reinstated. I think I'd modify it some to ensure, well, but it has him reside with his parents at the Revere Circle address, which is good. Okay. Let me hear from Mr. Rao. What is your view about where Mr. Remy ought to be between now and our next court appearance, where we'll figure out who's representing Mr. Remy and what they want to do with the case.
Yes, Judge. If it's my understanding, he received notice at the address that was listed on the bond order.
He didn't. I misspoke. What I said was the address of record. I didn't misspeak. The address of record is that Revere Circle address, but sometime between making bond in 2018, where he was required to live at Revere Circle, he relocated, and in the system was a Cherry Glen Road address. And so the notice went out to Cherry Glen Road. In the course of the 3 years of this case being in appellate limbo, it sounds like Mr. Remy had moved from there.
I'll defer to the court, Judge, with respect to the bond on Mr. Remy. Obviously, we still intend to prosecute the case.
Sure.
But I'll defer to the court.
Okay. Mr. Raines, anything you want to add?
Yes, sir, Judge. Judge, I would ask that you allow him to do an OR bond through pretrial. He's okay with checking in with pretrial pursuant to their requirements. I just think, Judge, and I said this back whenever we initially brought this case back before the court, that I think it's unfair to him that, you know, a 3-year, as you would say, Judge, limbo in the appellate posture. I think it's unfair to him to hold the fact that he moved during this process. In his mind, the case was dismissed. So I think it's unfair to hold the fact that he didn't make court back on March 25th against him, because he truly didn't have notice. The phone numbers that I had for him, Judge, 3 years is a long time. A lot of things change, his phone numbers, addresses. So I did try to reach out to his parents during that time period when I last appeared before the court. And I would just ask that you allow him to do a signature bond through pretrial services until we can work the remaining count out, that he be allowed to report to pretrial every other week, or whatever their reporting requirements are.
Okay. So I hear you. I didn't hear Mr. Rao making a big stink about the fact that Mr. Remy may have changed his address over the course of 3 years. He just heard what I had said, which was mistaken, that notice had been sent to where he was supposed to be, and it wasn't. So this is a peculiar posture. It sounds like there's not a debate that Mr. Remy shot and killed a man. The question is, was it in self-defense? And Judge Downs concluded after hearing the evidence at trial that it was a homicide. Mr. Remy killed someone, but it was justified. I heard none of the evidence. I'm not in a position to critique that. It is a ruling that withstood the scrutiny of our Supreme Court, and it's a ruling that stands. But it's not the case that Mr. Remy just missed a court date. Mr. Remy is someone who killed someone, and it went to trial. And then Judge Downs concluded that that killing was justifiable. And that's a complicated proposition just in and of itself. And there was a pending murder indictment for Mr. Remy after the Supreme Court did what it did. It's not one that the state can pursue in all its parts, but there's still 2 related active charges that flow from a situation in which, as I mentioned, Mr. Remy shot and killed someone. So it's real serious, and we need to treat it seriously. That said, given the amount of time Mr. Remy has already served and the likely disposition of this case, and the fact that Mr. Remy was on bond for a number of years and didn't get into any trouble, I think that reinstating the bond makes sense. I cannot legally issue a signature bond. for these charges. That is not something courts can do anymore. And so I think what is much simpler is to reinstate the bond that Judge Downs set. That required Mr. Remy to live at the address that we've got on record here, the one in Snellville with his family. And that way we'll be able to track him down. We know if something gets sent there and Mr. Remy misses court, that's on him and not on the Postal Service or the fact that 3 years passed or anything like that. So I'll expect Mr. Remy to make court each and every time, because notice will be sent to the address that he's told us here on the record is a good, safe, stable address for him. I may modify the bond a little bit. I'm not comfortable having Mr. Remy travel out of state until these charges are resolved. And I think we need to get this on a calendar in fairly short order to sort out representation, whether Mr. Raines will be staying on or whether there needs to be new counsel appointed to represent Mr. Remy. But the family of the deceased needs closure. Mr. Remy needs closure. But for now, these charges remain pending. So that's my plan. Mr. Raines, do you have any questions about that?
No objections, Judge. I think that's a very solid plan, sir.
Mr. Rao, any conditions to bond you'd want added? I know you don't have Judge Downs's bond in front of you. I can tell you that it has as a condition, obviously no contact with the victim's family. That remains in place. It had the requirement that he reside at this address that I first cited, the Revere Circle. I'm going to maintain that. And then I'm going to add the piece that he can't have any out-of-state travel. If that needs to be modified, that would require us to have a conversation if for some reason this case gets bogged down. But I'm hopeful that when someone can really plug in on his side and engage with you, given the amount of time Mr. Remy served, it's a matter that can be resolved.
Judge, the only condition I would add, and I apologize if you already said it, would be to have no firearms in his possession. I understand, obviously, him being a convicted felon, he's not supposed to, but
just make it double explicit.
Double explicit, and if there are any firearms at the residence where he intends to stay, as a condition of that bond, that those firearms be removed from that premises, effective immediately upon his return.
All right.
No objections to that, Judge. I mean, that's standard for bonds.
Yep. Got it. But just given the facts of this situation, I can say facts now because there was a trial. I think that makes sense. Ms. Rolak, was there anything that you have been asked to relay from the victim's family?
Good afternoon, Judge. We did not speak about exactly what was going to happen today.
Yep.
And so I was not asked to say anything. I can do a quick text and just see if there's something that's needed.
Why don't you just check in with them? I don't think anyone knew quite what the events would be for today, given the strange posture of this case. But I don't want to prevent them from having a voice if there's something they wanted to say.
Thank you, Judge. I'll do so.
Okay. Mr. Remy, while Ms. Rolak is checking with the victim's family, just so you know what's next, I'll enter a bond order that basically brings back the bond that Judge Downs had set. If for some reason you're not able to make that bond, we'll be getting back together pretty soon to figure out, is Mr. Raines going to stay on your case or do we need to get you a different lawyer? And at that time, we can talk more about bond or just resolving your case. But I'll take care of the paperwork from my end today or early next week, and we'll see where that gets you, okay?
Yes, sir.
I haven't received a response at this time, Judge.
Okay, thank you for checking, Ms. Rolak. All right, so that's what we're going to do with Mr. Remy. Mr. Raines, you'll get notice for the next calendar. If you have confirmed that you will be rolling off the case, you can just share that confirmation with Ms. Nelson, because I don't mean to keep dragging you into this, but until we know who else is going to be involved, we'll expect you to be plugging in, okay?
No worries, sir. I'm in Judge Carnicel's court right now. I'm back at the public defender's office, so it's no worries, sir.
I didn't realize that. That's okay. Small world. So you're around all the time.
Right. So it doesn't matter. I just sent Miss Stanley over at the GPDC a message asking what do they want me to do. So I'm here, so you can jerk my chain as much as you need to, and we'll figure it out.
Okay, we'll do that. Enjoy your break.
All right, Roger that, sir. May I be excused, sir?
Yes, sir. All right, Mr. Remy, we're done for today, but we'll get you back here soon. Either you'll come in because you made your bond, or you'll come in this way, and we'll chart the next step. Okay?
Yes, sir.
All right. Thanks, everyone. Thank you, Ms. Cullors, for covering for Ms. Crawford.
Not a problem. My pleasure.
Good seeing you, Judge.
Good seeing you.
And Judge McBurney, I have one thing to add.
Yes, sir.
During the course of court, I sent a text message to Mr. Brian Hobbs. He let me know that he was only retained for an unindicted marijuana case for Mr. Williams.
Okay.
That he did not have any intentions of taking on the rape case. So
great.
That's the update on that.
Thank you. Hopefully, Mr. Bridges learns that same bit, and we'll go from there. Appreciate the update.
Yes, sir.
All right, everyone. Have a great weekend.
Have a good weekend, Judge.
Mr. Parrish, did we skip one of your cases? I see that you're on the call, but I didn't see anything that was yours.
No, Judge, I just showed up to listen in on Mr. Williams' case.
Okay.
That rape case, it's in my division. It's not my case. It's a different judge. But I wanted to keep the attorney on that case abreast of what's going on. I'll make sure she is made aware of what's going on in terms of the attorney situation.
Excellent. Thank you.
Thank you, Judge. I appreciate it. You have a good weekend.
You too. All right. Samantha, I'll reach out to you when I get back into chambers, okay?
Okay, that's perfect. Thank you, Judge.
All right. Bye-bye.